Okay, well, good morning, everybody. My name is Colin Bennett from the University of Victoria in Canada. I think I might be the only person here actually representing a Canadian institution. I haven't found anybody else, but anyway, I say that. I don't know why I said that, but anyway. There needs to be more Canadians here. And I have the delightful pleasure of moderating this panel. One of our speakers could not make it, unfortunately, for health reasons. Klaudia could not make it. But we have three speakers today. Julia Krämer from Erasmus University, Jan Czarnocki from Leuven, and Karlo Lukic from Goethe University in Frankfurt. I'm not going to give large introductions, but I've given each of them for about 15 minutes to present their initial papers. The papers do speak to each other in interesting ways about online tracking and the compliance with the GDPR. So we'll have initial presentations of the papers, then questions to the individual speakers, and I'd like to leave about 10 minutes at the end for general discussions about the intersections between the papers and larger questions that might arise. So that's all from me. And so first I'd like to introduce Julia Krämer. She's a PhD candidate in empirical legal studies in the Department of Law and Business at Erasmus School in Rotterdam. And her paper is entitled The Death of Privacy Policies, How App Stores Shape GDPR Compliance of Apps. Julia, over to you.
Thanks a lot. So let's see if my slides are already... Oh, yes, perfect. Okay, so let me start by asking you, I guess some of you have come here outside from Brussels and might, as in my case, been completely overwhelmed by this public transport situation. And maybe some of you have then tried to have some help via this app of the public transport company, I guess, here in Brussels. And I know we're all privacy-sensitive people here, so of course you read the privacy policy, which in this case was only 6 pages long. But I also understand there are a lot of panels, we don't have time for that. But the app stores have come to our rescue, and they introduced a new tool, which are so-called privacy labels. And here you see a version of the Apple App Store. And in one glance, you actually see what data is collected of you. And I think it's a great idea to compare also between different apps, between different public transport apps, so forth. And this is exactly what we're going to talk about today. So my name is Julia Krämer, and I will be presenting to you my very first article that I've been writing in my PhD, with a dramatic title, The Death of Privacy Policies, How App Stores Shape GDPR Compliance of Apps. So what we're talking about is these two concepts of labels. So on the left-hand side, you see the privacy labels designed by Apple that have been introduced in 2020. On the right side, you see what Google has been coming up with. And this idea to actually illustrate privacy policies with the help of icons is not a new idea. So it's already been around since 2008. But the app stores are actually the first entity who introduced these labels on a large scale. And I think that's a quite interesting aspect as well, because there is years of discussion of inefficient transparency requirements in EU data protection law. So did the app stores actually achieve what years of regulatory efforts could not have done? And app stores, in that sense, are not only passive marketplaces for the distribution of apps. So previous research has actually identified that app stores act as so-called de facto privacy regulators, and they're able to do so because they're in a gatekeeper position. So most of you, I think, either use the Apple App Store or the Google Play Store when downloading apps. And of course, for developers who want to publish a successful apps, it's essential to get access to this App Store. So the entry requirements are quite crucial for developers. But of course, developers also need to comply with the provisions of the GDPR because it's about the processing of personal data. So on the other hand, then, when we look at the app stores, we do not really have platform-specific provision in EU data protection law. So app stores are not regarded as data controllers. Nonetheless, they have now this obligation for every new app and every update on an app to have these privacy labels. So I think it's a really interesting case study actually to look into this privacy regulator role of app stores, which is why I'm trying to answer the following question, or our overarching research question in my paper. To what extent do app store policies impact app compliance with provisions of the GDPR? And you see that this question is kind of targeting a more empirical reality, which is why I've been collecting a lot of app information to support the doctrinal analysis that I will present to you now. But of course, in order to see if there is compliance with the provisions of the GDPR, when we look at this new obligation of privacy labels, we actually have to check how these privacy labels comply with the GDPR. And I will, because of time reasons, just present you a short selection, but there's definitely more problems to it. But let me start by the categorization of different data types. So whereas the GDPR, of course, only differentiates between personal data and anonymized data, the app stores introduce quite some interesting data types, so to speak. So Apple, for instance, differentiates between data used to track you, data linked to you, and data not linked to you. And the Google Play Store, who introduced a completely different set of privacy labels, differentiates between data collected and data shared. And there have already been some empirical studies that actually show that these categories confuse users more than informing them about data processing practices. So it's quite doubtful if they would meet the standard of intelligibility laid down in Article 12 of the GDPR. What is furthermore quite problematic are so-called optional disclosures. So when you do not have to disclose processing practices. And the GDPR does not allow for this, but the app stores do. So for example, if data is only processed infrequently, without really knowing what infrequently means, you do not have to disclose privacy labels as a developer. But this goes, of course, against the whole purpose of transparency requirements in data protection law, because in order to make an informed decision, we need to know what data of us is processed. Furthermore, what is quite problematic is different definitions of privacy core concepts. So just to name an example, the definition of tracking or the guidance of tracking provided in the GDPR focuses on the result. So if a profile of you is created to predict certain behavior. Apple and Google, however, focus not really on what is happening, but by whom it is done. And I think that's also quite problematic, since there are also, of course, data protection risks associated when a certain practice is happening, not by the actor who is performing it. But what is quite interesting now, of course, what you could ask is, okay, this might not be compliant with the GDPR, so maybe we could address the app stores and just make them complying. But this is not as easy as it seems. So, as we know, under the GDPR, data controllers are addressees of most legal obligations. And in order to be considered a data controller, you have to define the purposes and means of data processing. And in the digital mobile ecosystem, we have different actors responsible for data protection compliance. So of course, first of all, we have the developers, which makes quite sense, right? So if somebody is creating a malicious app, they are responsible that data is not misused. Furthermore, of course, we have the app stores. This relates to the points that I've previously mentioned, that they're quite powerful in the gatekeeper position in enforcing and imposing certain entry requirements. So they really have an effect on developers. And furthermore, we have operating system and device manufacturers. So of course, if you create a phone that is able to recognize your fingerprint, there is a data protection risk associated with it. So we see some responsibility here as well. However, as it currently stands, and again for the processing of data within apps, actually only developers are currently considered as defining purposes and means of data processing. So that does not account for the data that the app stores are actually collecting about us, which is also quite a lot. So for example, which apps you actually downloaded. But for these privacy labels that inform about the data processing within apps, they cannot be held accountable. But of course, this only becomes relevant if developers actually accept these labels and implement them. And for this reason, I have collected a lot of app information. So I've been writing a web scraper, and how successful I was in scraping information of privacy labels, privacy policies, but also just general information of apps you see here. So in the first row of this table, you see the total number of apps. And this is another issue because the app stores actually do not disclose all the apps that they have. So we have to rely here on third parties. But according to Statista, we have in the Apple App Store around 1.6 million apps. And I have been able to collect roughly half of it. And in the Google Play Store, we have 3.5 million apps. And I could collect app information of 1.6 million apps. And you see, for robustness checks, I also collected in different geolocations. But today, we're only talking about the scrape that I done in the German geolocation. And the information I'm providing you now is from December 2022. So let's dive into the results. And again, the paper that I have been writing covers more, but I will only focus on a finding that I call problematic sense of security, and I will introduce this to you now. So for you to just get an idea how many developers have actually accepted and implemented these labels on their app page, you can see here. So 40% of the apps in my sample of the Apple App Store have no information yet. 34% have implemented them. And 25% have acknowledged these labels, but they just say, we don't collect any data, so no way to worry, but we acknowledge privacy labels. In the Google Play Store, this number is of non-compliance is slightly larger. So it's 57%. That's just due to the fact that Google has implemented this obligation a year ago, whereas the obligation for developers in the Apple App Store already exists since 2020. And to understand the next graph, just one refreshment of these different data types that Apple is introducing in the Apple App Store. So they differentiate between data not linked to you, which I would say is like the definition of anonymized data in the GDPR, or quite similar to it. We have data linked to you, which would be like the definition of personal data in the GDPR. And there's a third category called data used to track you. So that aims, I think, to really make people aware where data collection is actually quite risky. And I think that's a really nice idea. So how does this actually work out in our sample that I've collected? So here you see this bar graph. And on the left-hand side, you see the different data categories. So for example, location data, the search history, or identifiers. And you can see how often they occur, so how often they have been collected, and also to which data type they have been associated with. So you see that this personal data category or data linked to you is the most, or the biggest type collected, and data tracked, the last one. And then, however, was interested, how does this actually relate to Apple's own apps? So I want to show you this graph. And maybe you see kind of a pattern here. So just to again go to the full sample and to Apple's sample. And it seems like Apple apps are not tracking our data, which is great. So Apple is apparently holding to their nice advertisements that they take our privacy seriously. Then, however, I got still a bit suspicious. So I had another look at this definition, data used to track you. And I think there we should channel our attention, because it's defined as data used to track you across apps and websites owned by other companies. And that's, I think, the important word here, because, of course, if you have the example of Shazam and Apple Music, Shazam is owned by Apple as well as Apple Music. So if data is shared between Shazam and Apple Music, it's not considered tracking because it happens in Apple's digital ecosystem. But if a smaller developer team is doing it, it's considered tracking. So I hope you see that this is a bit like preferencing Apple's own apps, in my opinion. And I think that's a great example, accentuated by the quote by Waldman. Industry may say it wants to do better when it comes to privacy, but only if privacy means what industry wants it to mean. And I can also assure you that the same pattern you see in the Google Play Store, so Apple is not the only actor involved in this. And again, I think privacy labels are a great idea. I think they really have the potential to inform us in a better way next to privacy policies. I also think having this category data tracking you is actually also a quite nice idea. So we see where we have higher privacy risks. However, if we leave this to Google and Apple, you see what is happening. It's not really helping us to really understand what is happening with our data. So these privacy labels may convey a false sense of security. Furthermore, I think these findings have shown that app stores definitely have the potential to distort compliance of apps with the GDPR, but of course they can also increase it. So I think they're in a really powerful position, but as it stands at the moment, data protection law cannot do anything to capture that. So we will actually see with the DSA if there's a way. But yeah, at the moment, I think that's how it is. So I hope this could just give you a good idea of the basic idea that I wanted to convey with this paper. And since this is pretty much a work in progress, I'm happy for any comments or suggestions you might have. And yeah, thanks a lot for listening.
Thank you, Julia. So 5 minutes now for any questions you have on that. Please, could you use the mic? And I'm told to ask you to identify yourself. Please.
Thank you. I'm Lukic of the Dutch DPA.
I think you should.
It should be on.
Oh yeah, now it's working.
Thank you. Lukic of the Dutch DPA. I find it really interesting how those gatekeepers who are usually use their power to distort the market, according to your research, use their power for good, or at least seemingly good. How do you think that the DMA, where the gatekeeper is a key word, obviously, how that will interact with these current practices? Mm-hmm. And also, in the DSA, there is an obligation for service providers to verify some of the information that is put on digital marketplaces. Do you think maybe checking the privacy of apps and the accuracy of these labels should be added to the list of information that should be checked? Thank you.
Thanks a lot for your question. So I think, just my own feeling about the DMA, that even we get access to more app stores, I'm not sure if that actually really will influence the current power relation that we have, because of course developers still want to choose the app store where they can reach most users, and that's still the Google Play Store and the Apple App Store, even if we have the possibility to have different app stores. So I see, for example, that there could be maybe special app stores, for example, for privacy-sensitive apps that then maybe people like us will be using. But I think for the general public, I'm not too optimistic. But I mean, I guess we will find out soon. With the DSA, indeed, there are some obligations, such as Article 25, for example, that also influences the ranking of search results and this. I'm, however, not sure if labels like this would be targeted. I think that's something that we will also find out, because app stores actually have been labeled as VLOPs. So there will be maybe some regulation be applied to them soon. But yeah, I think that's the future to decide. But what I think would probably change is just to have a regulation to not self-preference own apps, because I think if they would have to have the same conditions for everyone, we would not see this design of labels. because then I think we would have a quite different graph. Yeah, so thanks a lot for the question. I hope that answered it.
Thank you.
Hi, Christina Bonova, Maastricht University. I have actually a need for some further explanation. Maybe it's just my brain after the 2 days, or I don't know, there's a piece of information missing for me. You were talking about the App Store showing the labels, right?
Yeah.
It's the App Stores, but it's the apps processing the data. And what I find interesting is your research questions. It doesn't matter if it's not on the slide anymore, but it was phrased in a way that the App Store would provide the information instead of the apps, or it would fulfill the obligation of information, but it's the apps who are liable, right?
Exactly, yeah.
What is the relationship, or what is the piece of information I'm missing there? Like, how can App Store do this instead of the...
No, thanks a lot for the question. I will clarify.
Thank you.
So what we see is, I think, quite a paradox. So we have, on the one hand, these transparency obligations that are applying for data processing within apps. Yeah. Then we have the app stores enforcing different policies via contractual terms to developers that developers have to comply with if they want to offer their app to the app store. And in this contractual obligation, you also have the obligation to put a privacy label. But because they're not data controllers, they cannot be targeted by the GDPR in this case for compliance with Article 12 to Article 14, which define the transparency requirements in EU data protection law. So we see them influencing potential compliance because, again, developers have to put these labels, and as you have seen, they are quite, I think not super understandable, so would probably not meet the transparency standard. But yeah, we cannot target the App Store. So I think it's quite of a paradox that I also wanted to put a bit highlight on with this paper. So I hope that clarified it a bit further. Okay. Perfect. Thanks a lot.
Hi, good morning. My name is Renato Sobadini, VUB. Same premise as the previous questioner. I also might be tired on the third day. Going to one of your slides, the one where you compare the categorization of data, comparing between GDPR, Apple, and Google Store, I was struck by, speaking of labels, by the icons you chose. There was a cross in green and a tick sign in red.
Yes.
So, which is quite counterintuitive. Could you...
Exactly. Yeah, sorry. With the optional disclosures, so I think it's something which is posing a lot of privacy risks, as I said, because in transparency obligations, I mean, the purpose is to inform us about data processing practice so we can make an informed decision. And if we then do not get disclosed all the information, I think that's negative, which is why I made it red to say that it's negative and green to make it positive. But the Apple and Google allow for optional disclosures, which is why I put this positive symbol. So yeah, I see that's a bit confusing, so I should definitely take care of that in the next presentation. Thanks a lot.
Okay, thanks, Julia. We should move on now to the next speaker. So, Jan?
Yeah, sure.
Jan Czarnocki is a doctoral researcher and Marie Curie Fellow at the Leuven Center for IT and IP Law. Your presentation up?
I hope, can you guys put it on? Thank you very much. Let me put the timer on, and here we go. No, okay. Thank you very much. Thank you for being here. This last day, I would like to present you my paper. This is part of my broader PhD research on legitimate interest as a basis for data processing and also proportionality principle, but also sensitive data. But it's a bit of a sidetrack to my main PhD question. However, I think it's still very relevant. So the title is Addressing Legitimacy and Data Power Through Qualified Transparency in the GDPR. So maybe why I'm even thinking about this kind of things like data power and legitimacy, this first I owe you some explanation, is that during my PhD track, I was keep on thinking like, why is it that we are having a GDPR in place, and we still have all these nasty things happening to us, like nudging, dark patterns, and all this, let's say, autonomy erosion all around the place. That we have this law, and still a lot of things that's wrong with personal data processing, or more effects of these things, are still in place. So I kept on reading GDPR, and we are seeing the principle of lawfulness, that you comply with rules, everything is fine. And there were some few mentions about legitimacy in the GDPR, but they were very unclear and very, let's say, not well explained to me, basically. So what I will talk about, first I will explain what I mean by data power. This is a concept by Orla Linsky. Then I will talk a bit about legitimacy of personal data processing, and how this is also reflected kind of in this personal data-based processing economy, because as a matter of fact, I think that personal data is an important factor in the digital economy, and how GDPR is and aims to be a measure to legitimize the personal data processing, but how at the same time it to some extent fails to achieve this legitimization outcome, let's say. I'll also talk about then structural imbalance of power in the GDPR between data controllers, especially data power controllers, and as well data subjects. Then I will propose some ways to ameliorate this, let's say, predicament, let's call it like this, through qualified transparency, which I will later explain. So my hypothesis here is that the issue of legitimacy has not been solved with the GDPR. So GDPR there are two goals of GDPR, basically: to protect the right to privacy and data protection as a fundamental rights, but at the same time to allow free flows of data. So this is kind of a way to find a middle ground, find a balance, so when you comply with the rules, the processing is legitimate. So like when you read the GDPR just plainly the text, you can assume that what's lawful is legitimate. When you comply with the rules, the processing is legitimate. But in my view, there is much more to the question of legitimacy in GDPR, and not everything that is lawful can be legitimate. And I was starting to think, well, maybe we can, we have this personal data. Personal data relates to power, so let's go now to power. And maybe let's clarify first of all why I think personal data processing merits raising the issue of legitimacy, because legitimacy is a huge, huge concept. It's very wide. You can put there a lot of things. But for me, legitimacy is justification of power, of exercising power. There are a lot of levels of legitimacy: moral, legal, and political. But what it boils down to is how we justify the exercise of power. And my take is that in the current political economy, personal data processing is a factor of power. If we are processing enough personal data with enough sophisticated technical and organizational capacities, let's say, like artificial intelligence system, but then we have huge company with an institution itself, this can be a factor of power, because through this personal data we can actively impact people's behavior. So the personal data is factor of power given certain conditions, organizational and institutional conditions are met. Let me see how much time I have. Okay, let's go further then. So Orla Linsky, her paper really inspired me. She's talking about data power a lot, from also how GDPR there is insufficient to address data power. She's talking about competition issues as well. But for me, I took this concept of data power and I started to think what we can do within the GDPR to somehow ameliorate this legitimacy, and what's wrong beside what Orla Linsky said. So we are having this autonomy erosion, nudging, all this stuff, and GDPR does not seem to solve this issue. Of course, in DSA, some other new laws, these laws aim to address this. AI Act also, like this manipulative AIs, they will be prohibited, etc. But still, I think that because it's all personal data based, all these processes, we should find some ways to solve it at the GDPR level. So let's move on further. So, of course, as well, processing personal data is a structural feature of contemporary political economy, and I think it's a fact that there's so much value derived from personal data processing. Not to say that it's whether good or bad, but it is the fact. So what is the legitimacy? I already explained it. This is how we explain, how we justify, what arguments we put to justify this power related to personal data processing. And I think this issue is not addressed well enough in GDPR because we don't require controllers who can be labeled as data power processing controllers. Then I will explain what I mean by this at the end. I don't think we require from them enough good arguments to justify what they are doing, basically. We have risk-based approach, of course, so they need to self-assess. We have some kind of measures of transparency, but I think it's not enough because structurally data subjects are kind of left alone against these powerful controllers. Of course, they have to inform, they have to be, to some extent, transparent, they have to be accountable, but all in all, we don't really know that much by default what's happening with all this data processing. Not that much information is disclosed, and what is disclosed, this is problem of squaring this comprehensibility of the language by which the things should be explained to people, and then like level of detail which no one will read after all. So this is also the problem by itself, but the matter of the fact is that data subjects are put it alone against these big data controllers, and this is a kind of a private law relationship that we don't have any, let's say, bigger brother to help us a bit. Of course, we can fill in complaint, etc., but at the initial state, we are alone. So that's why I think that the GDPR itself does not provide for a proper balance. That there's a structural imbalance in GDPR between data subject and data power controller. And this is also, as I talked, related to risk-based approach. So now let's go to how I envision that we can a bit improve the situation. This is not a silver bullet, of course, but this is just the beginning. We have this issue of legitimacy, so that if we assume that the personal data processing, if it's connected with enough organizational capacities and technical capacities, is related to power, then we also have to assume that private law relationship that is between controller and data subject may be not enough, because there's huge power asymmetry. So, and then these data controllers can impact the behavior. You have also a lot of competition issues that, for example, you don't have much alternative to use certain platforms. I really would say that there's not much, depending on where you are, there's not much alternative to using WhatsApp because your friends are on WhatsApp, some on Facebook, of course. You can argue with me, but I think that because of network effects, there's limited scope of what we can choose, which platform we can choose. So there's not much alternative. And then we have this private law relationship between controller and data subject, which make it hard to basically oppose and scrutinize what they are doing. So what I would like to propose is that we have qualified transparency. Qualified transparency would be asking by default to publish data protection impact assessment upon crossing certain threshold of data power. I haven't figured out what this threshold would be precisely be it, because there are two dimensions to it. There's this dimension of being very big, having a lot of variety of data, and being a huge organization. So this perhaps could be related somehow to being a gatekeeper from the competition law, or this now very large platform in DSA. But then you also have these sectoral data power companies that they are, I don't know, for example, fitness tracking apps, that they process a lot of biometric data and they can nudge you. And they're maybe not such a big players as Facebook or Google, but they still can exercise considerable amount of power. So how to basically define this data power controller is a problematic thing. But still, what I think would be the added value of having these DPIAs published by default upon reaching certain threshold is that we would have more transparency. What that would mean? It would mean that this relationship between controller and data subject would be less of a private law relationship at this point, but more of a more public, not in the sense that public law relationship, but more public, like subject to the scrutiny, for example, of civil society, watchdogs, organizations, data protection authorities, or researchers who can data mine these DPIAs and see what's then happening. So if we assume also that with GDPR, it's a bit that a lot of things can go, and it's to far extent what arguments you can put to justify your processing, to justify the risk you take. Then I would say to actually make it workable and challengeable by people is that you disclose these reasons. Because now you don't have to that much disclose this reason. If you really read privacy policies, like this all disclosure obligations which we have right now, it's really, there's not that much content in my view to it, that why you actually think it is really justified. These assessments are not published, and I think they should be published. And in this way, not that every data subject will be going and reading it, will be more conscious. I don't believe in it, but I feel that specialized people, watchdogs, civil society could then scrutinize and then challenge it on a merit basis, that the controller puts argument. I think I can process this data based on this and this legal ground. I think I take this and that risk, and I think this and this is justified because I have right to do it, I have interest to do it, etc. And then we have, on the other side, data subjects, civil society, researchers, which can openly challenge it, which can openly then inform data protection authorities, file a complaint, for example, because there's much more information in this space flowing about how actually this processing looks like. Because now what the problem I find is that based only on privacy policy, all these notifications, I don't really know whether they're doing something good or wrong, because all these words are so wrong. And if we force them to present precise arguments, then we'll have more ground to really actually discuss and forge, so by deliberative process, what kind of processings should be allowed or not. And I think it's a especially important factor within this, let's say, data power controllers. And so this is a very much deliberative democracy perspective on how personal data processing should be. Because I assume that to some extent, personal data processing is kind of inevitable, that we have these information technologies. That's how world is developing. I mean, it's not this ideology of inevitability and determinism, but as a matter of fact, they exist, and we have to somehow cope with it. So I think that we need much more information about what's actually happening, and not hiding again, with this corporate veil, but now in the form of risk-based approach, which is good. But we need to know more. What risk are you actually taking? So that's my basically solution. Of course, this is not a silver bullet. I'll be very, very happy to hear your thoughts about it, to challenge this idea. This is idea in work. And in my paper also provide some kind of a theoretical framework to explain more about legitimacy of personal data processing and why this is such a critical issue that merits raising this very, very big question of legitimacy, because I think that throwing this word of legitimacy somewhere in there irresponsibly is bad. At the same time, I don't think that GDPR, that you can just equate lawfulness to legitimacy and that GDPR solved the issue and you comply and then it's fine. So I think I'm good on time. Thank you very much, and we'll be happy to hear your questions.
Hello everyone, Koen van Kert, also researcher at KU Leuven Center for IT and IP Law. I actually had one question, Jan, about the action possibilities for data subjects in what I understand is an attempt to redistribute data power from control solely to the controller to data subjects. You mentioned that it would happen through the normal court system and through the regulators. However, there are two thoughts that came to my mind. Is first of all, how can you guarantee effectiveness for that? Because it is ex post and depends on the goodwill and resources of data subjects who will file those claims, thus providing for perhaps an uneven distribution or not as legitimate as you would want it to be. Another question is, you mentioned a mandatory data protection impact assessment. Sure, but also when you say that the assessment of legitimate interest is solely done by the controller, so would that DPIA be, unless if there is a really high risk that they have to notify the authority. Would there be an ex ante involvement of data subjects? More general questions to perhaps explain your stance on this perspective.
Could you reiterate on the second question? Just
On the second question is essentially with the data protection impact assessment, it's still an obligation of the controller. Do you consider ex post assessment through the litigation system enough, or do you think an ex ante assessment would also assist your goal of redistributing data power? What would your thoughts be on that?
Okay, let me start from the first question. The aim would be here, this solution I think is a starting point. I don't see it much as a way to distribute. Yeah, distributing power is an interesting perspective on this. I mean, how I envision it is that, and it's not clear to me based on the GDPR right now whether it's possible, but maybe we should have some amendment on this as well, that complaints can be filed on behalf of data subjects. So kind of class actions. This is also a novelty which because of lack of space, I didn't mention. But I think that there should be some space for filing class actions against huge abuses, and based on, for example, these DPIAs. Second question, sorry, I didn't understand actually.
Well, the question is essentially whether the ex post assessment, the ex post action against the processing which is already going on, whether that will be sufficient for you. If yes, why?
I don't think it's a question of sufficient or not, basically, for me. It's just like, what I'm just thinking about is just the beginning, and let's see what will happen with this, basically. I don't think it's a silver bullet. This just make more deliberation and space for democratic action. So I don't know how much it will be effective. It's just very hard to assess, because like, who would expect that 5 years after GDPR will have, like, no one knows what will be the effect. That's the reason why we are meeting at this conference. I just think that opening up this space for more information flow about personal data processing is a way to make interesting things happen and create this space for challenging. I don't know whether that satisfies you.
It does. I tend to agree, and perhaps my discussion would be for a later iteration of policy or a later day. But anyways, you answered my question perfectly. Thank you.
Thank you, Kun.
I'm Farid Basuli, LLM student at Tilburg University. Thank you for your presentation. I don't want to sound too pessimistic, but how do you think that this solution can help address structural issues? Like, to what extent? Because to me, I mean, it would somehow be adding some kind of layer of, okay, transparency, but at the same time, will it really have effects on those structural problems that you mentioned about, the imbalance of power? I mean, for instance, the system that you presented for the previous paper, I think, for instance, is useful for consumers to have more information and then being empowered and everything. But then, yeah, what's your stance about that?
I think my assumption here with this proposal is that I think that power, a huge factor for power is that it's clandestine, it's hidden, it's opaque. You have these huge law firms which are making this kind of documentation for you for these thousands or hundreds of thousands of dollars, and then you throw these documents in the face of data protection authorities, and here we go, we are compliant. But it's all like walled around because there's like a lot of confidentiality. So my idea is that if we open it up itself, it undermines this power. So it brings a bit more balance, and if you perhaps merge it with kind of a data subjects or like data protection class actions, something like this, some new processes maybe open up that will actually create a bit more balance. So I don't think it's creating a balance by itself, but the consequences of it, having it in the back of your head as a big controller that this will be published. So this is also a PR issue. We can take a lot of damage if we screw it. I think this might open up a process for leveling the playing field. Of course, I don't believe that data subjects by itself, they will be acting on this. They just don't have time. But we are here specialized at CPDP, and it will be our goal to do it, if it is, of course, possible. I don't know. Hope it satisfies you. If it doesn't,
I mean, I'm dissatisfied with the system. Of course, it's not a silver bullet, as you said. I really hope that it evolves positively. But I mean, I'm thinking about, for instance, also the consequences for AI, There are also all of those steps about, depending on the risk, transparency. But in the end, I think there are still some issues that remain, as you said, structural. And for instance, I mean, you mentioned, power imbalance. But for instance, if companies hide behind trade secrets, for instance, then what can you do about it? Like, those are things that I think, in my opinion, but then of course.
Yeah, I think that what you said about trade secrets is extremely relevant. I will have to research trade secrets a bit more, because how these things overlaps, the publishing by default and having all these trade secrets as well is a different area of research. But I think this is a very, very relevant point, but I didn't have much time yet to dwell into it. And with data protection impact assessment, if you use these AI algorithms, you should already take it into consideration when you describe the risks. And in the AI Act, in these drafts, there's also a lot about risk assessments. It's just all about making it more public. Let's publish it more. This is real accountability and real transparency. And otherwise, it's not that meaningful. If you have a whistleblower, then, but not that much whistleblowers.
Okay,
Thank you.
Thanks. We'll now move on to Karlo. Karlo Lukic is from Goethe University in Frankfurt, where he's a doctoral candidate. Please.
Thank you, Colin. Thanks to the organizers for giving us the opportunity to present this project. Thanks to all of you who decided to choose this session and spend some time with us here talking about GDPR. So my paper is called The Impact of GDPR on Online Tracking. It's a joint work with Klaus Miller and Bernd Skiera. They are unfortunately not here. They're at a different conference currently. So I want to first start with the description of why we actually started this research project. Sorry. And that's the description of the problem that motivated us to do this kind of research in the first place. And that's the fact that most websites, such as CNN, use and rely on website online trackers. And that's mainly for two reasons. Mainly to display or to monetize content of the users, to display them advertisements, and or to enhance the user experience. And so while this has advantages for the websites, it also comes with the privacy costs for the users, right? And the privacy implications. And so the regulators basically stepped in 2018, as you probably know, and enacted the GDPR to try to increase the privacy of online users. And so in this case, this visiting CNN was yesterday. It uses 45 trackers, 5 years basically after the GDPR. So what we were asking in this paper is kind of the elephant in the room question. Did GDPR's enactment actually increase the privacy of online users? More specifically, we asked two research questions. The first one, and that's the one I'm going to cover today, is basically, did GDPR decrease the quantity of online tracking? I'll be talking about mainly the number of trackers. That's how we measure the quantity of online tracking. In the paper, we also look at the intensity of online tracking by looking at the share, for example, of tracked pages. And we mainly think this has relevance for the users and the regulators. For the users, basically saying something about did GDPR increase their privacy, and for the regulators, whether GDPR achieved its aim, and maybe we can provide some insight for the upcoming regulations. So what I'm going to cover next is a bit of background about the online tracking market. I have one slide on GDPR. You probably already know everything about GDPR. And then I'm going to cover how we set up the study and some of the main results we currently have. So for the description of tracker market structure, some definitions we use in the paper: online tracking, simply collecting data about users over time. It's mostly in line with the previous literature. Tracker is simply a software that is installed on one or many web pages of a website to track users using any kind of tracking technology that can be, as you're probably familiar with, cookies, but it can also be fingerprinting, for example. Tracker provider is a company that develops one or more of these trackers. And the website is simply a company that uses them. So here I had the hypothetical example, one-on-one, how online tracking works, why this happens in the first place. Basically, let's pretend we are a website and we are we are a news publisher like CNN, and we are at some point delivering high quality content to online users. At some point, we generate the traffic, so the users start visiting the website, and at some point, we also would like to do something with that user's data. And at this point, we can basically design our own in-house solutions, so to say. So we can develop, for example, solutions to enhance the user experience, to display advertisements to the users. But most often than not, there are already existing solutions on the market, and they're also convenient to use, and they're also sometimes even free for us as a website to use. And at this point, basically, the tracker provider comes into play, providing a tracker that can basically solve all our problems as a website in this case. So we mainly get two benefits as a website. In this case, we can use data for more targeted advertising, and we can also use the data for better user experience, for example. But so that would be the simplest case. In reality, as you also probably know, many websites use multiple different kinds of trackers. So you can think of, I don't know, tracker 1 could be something like Google Analytics. Tracker 2 could be something like a DoubleClick for targeted advertisements. And Tracker 3 could be something like Facebook's plugin or social media widgets. So what winds up happening is that multiple different websites start using the same set of trackers, which are then owned by the same tracking providers, and that gives great rise to these privacy concerns and gives these tracker providers high power in terms of data collection of those of the same set of users. So for the GDPR, short slide, online privacy law enacted in May. Overarching aim is to increase EU users' online privacy, area of application, European Union. Applies to simply, in our case, simply we say any site worldwide that tracks users from the EU region. There are many important changes that GDPR brought up. In our setting, we mostly focus on these. So those are basically consent notices, i.e. cookie banners, which would then act as a mechanism by which the users could regulate the number of trackers on the websites, and high non-compliance fines, which would be an incentive for the website to comply with the law, basically. So how we actually do this, we rely on two data sources currently. The first one is Who Tracks Me? That's publicly available data. Anybody can download it, anybody can look at it. Basically gives us information on tracking measures. So these are the quantity and intensity of online tracking. We monitor 717 websites. So these are popular websites such as CNN, but also different ones. Each website is accessed by both the European users, so users located within the EU region, and the US users. So those are representing our non-EU region. And so we say that the unit of observation in this study is basically a site instance. So in our case, that represents 2 site instances per website. And we monitor them each month from April 2018 to December 2019. We would love to have a longer pre-GDPR period, so more than, so coming even longer behind the April 2018, but that's the limitation of this data set. And we look at them at 21 months. And we use a balanced panel of observations. On the other hand, we have similar data, a similar web, that complements this main data set of Who Tracks Me, basically to allow us to find the website target audience. So we look at the share of users coming from EU region versus non-EU region that will then allow us to split those websites at the later stage to non-EU websites and EU websites. And there we have 2 basically sets of data. We have scraped data and acquired data. In the main analysis, we use the scraped data set, but we also have the acquired data, which basically acts as a robustness check to check that scraped data set. So a bit about a dependent variable. So we used a distinct number of trackers per website instance. So this looks at the following illustrative example. So let's say, so we would have a user location, users within the EU, and the users outside of the EU, that will be the US users, representing our 2 site instances, and then the users basically browse different web pages of a website, which would then have different numbers of trackers. And in the end, we basically look at this number. So in the EU case, that will be 46 trackers. For the US, it will be 48. So we basically take the higher number. And to operationalize this increase in online privacy, we simply say it's represented by a decrease in the distinct numbers of trackers. Right, so the basic idea of the analysis is to use a diff and diff design. So it's the idea of, from medical also research to have kind of treatment and control group being treated with GDPR, control group not being treated. And then for that, we also need 2 periods, so before and after periods. So as I mentioned, we already have this time frame in mind, so April 2018 to December. We actually can use data up until the last month, so that will be April 2023. But we don't do that because the California Consumer Privacy Act was enacted, as you probably know, on January 1st, 2020, which could potentially bias our US portion of the data. That's the main reason why we stopped at December 2019. For the treatment assignment framework, we use the following framework. So the blue cell is basically our control group, and the green cell, the combination of all three, the yellow cells are basically our treatment group, and the blue cell is the control group. So as I mentioned, we have the data on the user location, EU versus non-EU, non-EU being US. And then we also have the website designation status. We simply say that the non-EU websites are those that need to have 2 criteria fulfilled. So those are, they need to have a non-European top-level domain. So you can think .com domain, for example. And they need to have majority of website traffic coming from the non-EU region. In any other case, it's a matter of European website. And then we look at the blue cells, basically. That's our control group, as I mentioned. So those are the non-European websites visited by non-European-based users. In all other cases, we are talking about a treatment group. So for the results of the study, we basically, these are the before and after for the 2 groups. So you can basically see this increase in the quantity of online tracking after GDPR. So before GDPR, there is also no significant difference between the 2 groups of users. 2 groups of, so the treatment and the control group. And after, there is also a significant difference between the groups. And at this point, we can also take basically the difference in differences, which would be, as mentioned, difference in differences of those. And we can calculate this kind of the effect of GDPR, which in this case would be lowering the number of online trackers by minus 1.971 trackers, i.e. minus 2 trackers. We can come to the same kind of difference in differences using this cross table that's taking similar as the previous graph, so the mean number of trackers between the 2 groups and 2 periods. Before and after, we see a strong increase both in the treatment and the control group, but you can see the control group basically increased even more than the treatment group. And that's where the effect is coming from, basically. Again, taking the difference in differences, we have the same number, basically. Then plugging this into a regression-based model, we use a 2-way fixed effects regression, so controlling both for the website fixed effects and the month fixed effects. We come to the same difference in differences. Now we call it coefficient because it comes from the regression. And we see that it's a significant effect. Right, so I already teased this increase in online tracking for both groups. This is also looking at, again, model-free evidence, just taking the means over time. And you can basically see the small dip in the treatment group after GDPR, and then this increase in quantity of online tracking, and then kind of the steady state of online tracking from, say, March 2019. This is also backed by other research. There are colleagues working on this as well and showing pretty similar findings. Right, now taking the differences between these two groups that you just saw on the graph, we can look at the differences, so sort of the effect of GDPR over time. And here we can say basically 4 months after GDPR, this strong midterm effect, basically about -2 trackers, and then even stronger effect more than 6 months after GDPR. Now looking at and this is my last slide for the results, These are the differences between, on one hand side, so the left-hand side would be the website categories we had in the sample. On the right-hand side would be categories of trackers that we have in the sample. And here we basically see the effect for the business, entertainment, and news and portals websites. And we also see on the right-hand side the advertising analytics and essential trackers. Okay, so to summarize, we basically show that quantity following tracking increases over time. Treatment group increases by 7 trackers, on average control group by even more, so 9 trackers about. We observe that GDPR decreased this quantity following tracking by about 2 trackers. Converting that to percentage would be like a 10% change. We also see that GDPR impacted quantity following tracking weaker in this midterm that we label. That will be the 4 to 6 months after GDPR, and stronger in the long term. And we also see these differences in the effects on different kinds of websites, so business, entertainment, news websites, and different kinds of trackers. So advertising trackers had the largest effect. Okay, so thank you so much. I believe I'm at 14 minutes.
Yeah, no, very good.
Thank you.
So questions, please, Karlo.
Hi. Thank you for your presentation. I think the question you looked into was very interesting. I have 2 remarks methodology-wise, actually. First one is, you said that your time frame started April 2018.
Right.
Do you think it can already be biased because the companies might have prepared for the GDPR even before April 2018? Because
Right.
maybe there were more trackers before, or
Right.
less, or I don't know.
Right. Thank you for the excellent question. We have so Who Tracks Me also offers another sample, so we can kind of address this question with another sample of data. That one is available before April 2018, but the trade-off there is we don't have the data on the user location. We only have the data for global users, so we cannot say EU versus US, right? We run it as a robustness check, so we look at the same set of websites that we have in our sample, but without this information on the user location. And we look at for example, there whether we have some anticipatory effects, but we don't find the evidence for that. So, for example, we can run the same analysis on that one, which is basically the same effect. So we observe again for that sample, we observe about -2 trackers, basically. But there you can basically, for example, drop just March, April. You can drop those months from the analysis. That will be this one simple reason how we can address that. But in the main sample, we cannot say anything about that. Sure.
Okay, I understand that the data, if it's not available, then you cannot work with it. But
Right.
maybe just a remark for you then that I don't know if you have a disclaimer or something at the beginning of your paper that this might be a little bit biased. And also my second question, or also maybe just a remark, or maybe you will say it's completely okay methodology-wise, if you think that the results may be biased by the fact that you chose the US users, or if you think it would be the same everywhere else. Thank you.
Thanks. Well, so for this treatment assignment framework that we kind of thought of, we would need like the scenario of basically not being treated by the GDPR, right? And we know that's quite. We try to design strict criteria to account for that, to account for the cases, to say, okay, this is where the GDPR legally should not apply to. And in our case, those are the non-European users visiting non-European websites. Now, we have the data for the US users, but I think probably it would be similar results also for the other non-European users. It's just for us, again, just the data limitation. Thanks for the question.
So if I could ask a question then. I mean, I was struck by how minimal this reduction was. I mean, it really is quite staggering that the GDPR has not had a greater effect on this. Would you agree with that?
Yes.
So I mean, to infer or to interpret that somehow the minimal reduction that you're seeing is attributable to the GDPR, do you have to also assume, therefore, that the companies that are doing this tracking or installing the trackers are then thinking that what they're doing is potentially illegal and therefore they better not do it? I mean, is that a fair inference, or are there other explanations?
I think it's, you can say that there's your argument to kind of legalize it, right?
Yeah. Well, but if the GDPR is having that effect, then it has an effect through the assumption by these companies that what they are in fact doing is illegal under the GDPR. Would that be a correct assumption?
Yes.
It would, right. So in other words, there's an awful lot of illegality still going on.
Right.
Yeah, okay. I just wanted to make that point.
Yeah.
Please.
Yeah.
Or maybe the case is that they assume that it's legal because they did a lot of paperwork and they just justify it and people are agreeing on it, and the legal landscape is much more, let's say, certain now, and that's what they are doing because they are assuming it's fine. That's another take on this.
Because they think there's sufficient transparency in what they're doing, which there may be and there may not be, going to Julia's paper, that what they think they're doing is in fact legal.
I mean, sure, that could be one justification for what we observe, right?
Yeah, please.
Yeah, maybe to answer or not answer, but to react to that, I think that the trackers which are still being used after the GDPR, it can include also the illegal ones and also the ones, as the colleague already basically said, they just justified it or made it more transparent or just adjusted the way they use it, but they didn't have to stop using it at all, So I think there's two parts of that.
Well, I guess I'm putting there's a series of hypotheses there about what's explaining this. Yeah. Other questions? 5 minutes. 5 minutes for questions.
Otherwise, lunch.
Okay, if I get. Oh, please.
If anyone has comments, because all the papers are interconnected, do you have other comments?
Anything further, Julie? I think people want to have lunch.
Maybe at lunch, exactly.
Lunch.
Thank you.
Thanks so much.
Thank you very much.